This panel, we wanted to talk a little bit about the resident rights, the resident consultation, the relocation issues. As we've talked through the morning and as we continue, clearly the issues around involving the residents is a major issue and a major priority for the program. So we wanted to touch base on some of that and also some of the complexities around relocation, particularly when folks are doing a fairly significant transaction. So here at the table with me are Will Rudy, to my immediate left, is with the Office of Community Planning and Development, and that's the office that handles our HUD's Relocation, Uniform Relocation Act and other relocation concerns. And then to his left is Claude Dixon, who is within the Office of RECAP and is a senior advisor and has been really spending a lot of time on resident and relocation issues for the RAD conversions. So we want to start with a little bit of an overview. The RAD notice has a variety of resident consultation requirements that everyone will need to be aware of. One of them is something called the RAD Information Notice. And it is something that we want folks to send out to all of the residents, no matter what the nature of your RAD transaction. It's not tied to whether you're doing construction or not, or whether you're doing relocation or not. It's an attempt to get information to the residents so that they understand what their rights, RAD provides to the residents, and so that they understand some of what's being anticipated and under discussion. So the resident information notice, sorry, I forget whether it's the RAD information notice. I think it's the resident. All right, sorry. I should know my own vocabulary, huh? The RIN, that's the easier version, is a key thing that should happen right away. So if you, before your application goes in, so for anyone who is new to RAD, sending out the RIN when you get back to your office on Monday is a good idea. And there's a template on the RAD website for a RIN. You also want to be notifying the resident organization. That's a requirement of the program. And as part of that early planning, when you're thinking about the application and beginning to think about what you might do, you'll want to be thinking about how what the residents' needs are going to be during whatever your RAD transaction process is, and just start setting yourself up to do that planning carefully as you begin thinking about your RAD conversion. In terms of RAD requirements on resident consultation, there also is a requirement that there be at least 2 meetings with the residents to talk about the RAD plans before the application goes in. So before you get your CHAP, so this is something that you'll be working on if you submitted a letter of interest, something that you'll be working on in the next few weeks. And those 2 resident information meetings, what we're really trying to make sure is that the residents are aware this is happening and that you're creating an opportunity to have some conversation with them about what the housing authority is thinking about. We got a lot of feedback that folks didn't know what they were supposed to cover in those resident meetings. So the RAD notice gives some guidance on some minimum things that you need to talk about, particularly if you're thinking about doing a transfer of assistance to a new site. We want you to be engaging with the residents about that so that you hear their feedback and get their thoughts on how that might impact their lives. Whether you're partnering with a developer, whether you're planning to change the number or the configuration of the units, the unit mix, anything that might affect their ability to reoccupy or their temporary or long-term relocation, things about replacement of vacant units, and just sort of the sense of scale of the project that you're thinking about. This does not mean that that has to be the final decision, because we understand this is before the application, but we want you to be starting to talk with the residents about your thinking, even if your thinking is not fully fleshed out. So that before the application is going in, the residents are starting to become aware of the plans, and as a result are being able to contribute to the conversation about the Housing Authority's plans. So that's just sort of opening the conversation, and you don't have to have all of the answers, but you need to begin that conversation with them. Those are sort of the things before the application goes in. Whether it's before the application or while you're waiting for the CHAP to come or after the CHAP, you do want to be thinking about your relocation issues, and we'll go into this a little more in depth, but issuing the general information notice if it's required by the URA, thinking about your relocation planning. There is this, and Will mentioned the requirement that the annual plan reflect the RAD transaction. The annual plan process, as all Housing Authority leadership knows, involves a public hearing, involves consultation with residents there as well. And it's another venue for having that conversation about what the Housing Authority is thinking about. And continuing to advance the understanding that everyone in the community has about the potential and the challenges of a RAD conversion. These are not necessarily simple things, and for some folks, if it's a more complex transaction, it takes a little while to sort of get your head around what it is that might be being contemplated. We also want to particularly remind folks that there are fair housing considerations, that making sure that these resident meetings are accessible, have accommodation for folks with limited English proficiency, that kind of thing. So you do need to think about those things, and there are sort of reminders in the RAD notices in various places to make sure that folks are not forgetting the variety of other considerations when, unfortunately, there's so much going on that it's important to keep track of a lot of different balls that are up in the air at the same time. And then after the CHAP is issued, there is a requirement for at least one additional meeting with the residents. Many people rightly think that one additional meeting is not enough. But for a very simple transaction that is a straight conversion without construction, where the money is just being put aside for future construction, one meeting is enough. But we strongly encourage you to think about whether about additional meetings. And certainly we also do require you to have additional meetings if some of these key features, the things that are required in the first meeting, whether you're transferring assistance, whether you're getting a development partner, some of the stuff that really shapes the nature of the transaction. If your decision and thinking shifts, you do need to have additional meetings to cover those material changes beyond the one additional meeting if there was any significant change in your thinking. So there's certainly lots of best practices, and we hope during the course of this conversation and later through these days, today and tomorrow, you'll hear more examples. But that's sort of the quick overview of some of the resident consultation issues. And I'm hoping that Claude will talk a little bit about some of the resident rights.
Yes.
Do you want to?
I'm not going to speak so much as to the formal notices that have to be provided under RAD. I'd like to talk more about best practices. I think the lady who represented the Austin Housing Authority, and you saw the list of organizations that they engaged prior to undergoing their RAD conversion. that is a great example of getting the organizations that support or interact with your residents involved at the very beginning, which goes a long ways towards addressing resident concerns. There may be organizations that they turn to understand the RAD transaction or what's taking place, getting them involved so that they know what's going on, so that they can advise residents informally or however it is that their interaction is extremely important. The other thing I would strongly recommend is that we have notices that have to be given at certain periods of time, but these are people's homes, and they're very much concerned about what's taking place with this RAD transaction or RAD conversion, and they need to be kept informed as to what's going on. Regular meetings with people, giving people an opportunity to, get updated on what's going on, express any concerns, is really important in terms of giving residents a sense that they know what's going on. And even if, if for example, your tax credits get delayed for whatever reason, just telling people, well, there's going to be a delay in development, instead of just leaving people where, things just stop happening and they have no idea why.
So, do want to highlight a couple of the folks that are on a couple of the items that are on the screen about the right of return. Mm-hmm. We'll talk a little more about that in a few minutes. But the residents do have this right of return. There are also several pieces of the resident rights package that are bringing forward into the Section 8 context some of the features of public housing. The resident provisions within Section 8 and public housing are a little different. The basics are very parallel. Rent, the percentage of income as rent and that kind of thing, but there are some differences, and some of those differences have been incorporated into the RAD program and are reflected in the RAD contract documents. So it's important to note that while these are Section 8, there are some extra things that apply that are pulled forward from the public housing side. Things like the ability to form a resident organization, things like the tenant notifications and grievance procedures, and there are a small handful of those things. But I think that another piece that is particularly noteworthy in the resident rights context is choice mobility, and somebody mentioned that earlier this morning. The choice mobility feature is an existing feature of the housing choice, the PBV program, the project-based voucher program. And what it is that a resident who is living in a PBV program, in a PBV property, after a year of residency at the project-based voucher property, can request this choice mobility option, and they jump to the top of the waiting list for a mobile voucher. That doesn't change whether the project itself continues to receive subsidy, but it does mean that they have the ability to then take the mobile voucher and find housing in the market in whatever community they might want to live in. The choice mobility feature is an important part of RAD. In RAD, the choice mobility feature has been added to RAD PBRA contracts. In that context, the resident needs to have lived at the PBRA RAD site for 2 years, not 1 year, but they do have the same choice mobility feature. So I think it was Austin that was coming up on the time frame for when their choice mobility will kick in. There are some provisions in the RAD notice about sort of managing that. There are some provisions around keeping some of the waiting list for the mobile vouchers available for people who had been in the mobile voucher, on the mobile voucher waiting list, just in case sort of there was a bit of a surge of interest from folks moving out of project-based voucher locations, or ways to mitigate how many folks are moving all at once and that kind of thing. So as you get into the choice mobility rules, it's worth reading those in detail. But the choice mobility is a key feature for residents, and it's been designed based on the existing choice mobility in the project-based voucher program, and also expanded to the Rad PBRA contracts. So that is a new right for residents that they did not have available for them, that they did not have available when they were in public housing. So this is a list, you'll get it in the materials, but there are a variety of resident rights that are important things to think about as you're organizing your conversion. But I want to turn now to relocation, which is one of the areas that people really struggle to make sure that they are following the rules, and the rules are admittedly complex, and it's something that requires a fair amount of planning and attention to make sure that the residents are being treated properly under the Rad rules and under HUD rules generally. So, Will.
Before we get started, I wanted to thank Claude and Tom and the rest of the recap team. I mean, as transformative as Rad is to improving our inventory of affordable housing, it's also transformative within the HUD agency. I mean, we are working across program offices like we've never done before. I mean, it's my place at the table here, and we collectively have worked very closely together to put forth what we're going to start off with, this relocation notice that we issued back in 2016, which is really the guidebook for ensuring compliance with the civil rights, fair housing, and relocation requirements. I have it with me all the time. Everybody teases me about it. I don't go anywhere without it, and I would encourage you all to have one with you as well. That basically was updated from the relocation notice from 2014. So as Tom was mentioning, the RIN requirement, which is new, right? It's the first notification to residents. And we'll talk as we go with the questions with the GIN, which is the Uniform Relocation Act. That's another requirement when someone actually is going to be temporarily or permanently relocated. So let me just take a few seconds to kind of, on this slide, to give folks a little bit of a background, kind of a high-level background of what the URA is. I'm assuming most folks have a general understanding. It's been in law since 1971, signed by President Nixon, right? Congress recognized that the federal government had a responsibility to provide uniform and equitable treatment when people are going to be displaced or have to move for a federal project. And it put forth a lot of requirements to make sure that people are treated properly. And generally speaking, when we talk about the Uniform Relocation Act, is when there's an activity that includes acquisition, demolition, or rehabilitation. They may trigger the URA. But overall, the URA provides a framework for planning, communication, advisory services, and if someone is eligible and needs to move, a replacement housing payment to make sure that when they are moved into a replacement unit, that it's decent, safe, and sanitary, and that there's good housing outcomes. Section 104D. I think the latest numbers I've gotten from Claude is maybe 120, 130 million in home and CDBG dollars are part of the financing package. So when you have home and CDBG in a RAD transaction, there are other requirements, and this is one of them. It's the Section 104D of the Housing and Community Development Act of 1974. Sometimes it's known as the Barney Frank one-for-one replacement. So when there's demolition and conversion to a non-low income dwelling, this requirement kicks in. You know, it requires, and I think this is an important point, because we've seen some bumps in the road from some of the earlier transactions, that the home participating jurisdiction, right, the PJ, and the CDBG grantee have the administrative responsibility for making sure that their program requirements are being fulfilled. But it's also on the onus of the housing authority and the developing partners to make sure that these requirements are in play. So really what it does, it establishes this additional requirement that is not, and I wanted to take a second to mention this because it's not part of a regular RAD transaction, but you do have to have this additional requirement of a residential anti-displacement relocation assistance plan, and if you're a home and CDBG grantee, that's a requirement. It also ensures that these activities do not result in a net loss of affordable units, so there's the one-for-one replacement requirement. And then the third distinguishing characteristic of this requirement is the fact that there's an additional relocation enhancement. So under the URA, and we'll talk about that, if someone would have to move and they get a replacement housing payment, it's based on 42 months. Under this program, it's actually 60 months.
Well,
Sure.
I just want to highlight a couple things that I think sometimes people might miss. GIN issuance. When there's home or CDBG funds involved, the GIN issuance date changes from what's contained in the RAD notice.
Correct. That is correct.
Right. And could you just tell us when that would have to be issued?
So when we developed the 2014 notice, we incorporated HUD's administrative practice, which is you always issue a GIN. Even if folks were not going to be displaced, the requirement was you just notify folks. But we made the change that we would give a RAD information, a resident information notice, so everyone is getting the general information about what the project plans are, but tailoring the GIN to only those folks who are likely to have to move, either temporarily or permanently. However, and that's in the new notice, that has to be issued, the GIN has to be issued within 30 days of the CHAP. But if you have home in the transaction, and that's typically what we're seeing is home, and now with HTF as well, Housing Trust Fund, the GIN has to be issued at the time of the home application, which actually could be earlier on in the process. So there are these competing other program requirements under home and CDBG that need to be satisfied. At the same time, you need to satisfy the RAD URA requirements.
So there's sort of a layer cake element here.
Yes.
That the Uniform Relocation Act applies across the board. RAD has additional requirements, so the RAD Fair Housing, Civil Rights, and Relocation Notice is an effort to integrate how the URA and RAD work together, because both of those are applicable in every RAD transaction. And then the Section 104D requirements are only applicable if you have certain types of funding, specifically home and CDBG is the most common. And so the RAD notice doesn't have a lot of detail trying to integrate the 104D requirements because that is not uniformly applied. But if you do have those kinds of funds, you need to add on the analysis of the 104D. So the RAD relocation notice really tries to bring together and reconcile how the URA and the RAD requirements work together. And then you think about the 104D as an overlay if it kicks in. And then of course, all of these are subject to the background requirements related to fair housing and civil rights compliance. And so the RAD notice, the RAD relocation notice, fair housing, civil rights, and relocation notice highlights some of the places where those considerations are things that you may want to think a little extra about to make sure that all those pieces are working well.
Yeah.
So I think.
I just want to make one quick footnote that when you send the GIN, there is a form template attached to the notice. I would highly encourage that you send the entire template because if you don't, there's a chance that upon review, your GIN notice may be found to be defective, in which case you would be inviting yourself to a whole host of issues that I'm sure you don't want to deal with.
I think I want to just take a second to emphasize the GIN is exceptionally important, because if it's not done properly or not issued, then there could be the presumption that someone has been permanently displaced.
Right. And
When
you don't-
people move without being properly notified.
And a defective GIN is not a proper
proper.
notice under the URA.
Correct.
So the RIN describes the resident's rights, and the GIN is all of the URA stuff, all of the URA requirements and rights. And there are going to be pieces of the GIN that don't apply in a RAD context, or may not apply in a RAD context, but it is the thing that you want to do is be providing the GIN because it is fully descriptive of those rights, and then explaining to people what parts are particularly relevant to them. But you don't want to be just sort of deleting sections of the GIN, because then that raises serious concerns for our friends in the Uniform Relocation Act administration side of HUD. So that's sort of the overview, and we figured that it would be helpful to actually just sort of talk about some scenarios to try to make this a little more real rather than just dry rules. So we're going to shift to just sort of some more conversation about this stuff. And I wanted both Claude and Will to give sort of their views about the one thing that, when managing the resident transaction as it relates to the residents, what's sort of the first thing, the most important thing that each of you, as you're doing your compliance oversight, would want people to be doing?
Well, I think I sort of highlighted this concern. It's tenant engagement, keeping tenants involved, having regular meetings so that people know what's going on. And it doesn't just stop with just telling people about project plans. You might say, well, I'm doing in-place rehab, and that's minimally, disruptive to the tenants. Well, on one level, you're right, and on another level, you may not be quite so right, because you may be asking tenants to manage their lives around various degrees of construction, and they may have concerns about that. And you need a process, or I would highly recommend that you have processes for regular meetings with people, giving them an opportunity to register their complaints or concerns, and a process for responding to them. Because PHAs who have had those processes in place have had fewer problems, quite frankly. Those who have not kept their residents informed have often created problems for themselves.
And I think a best practice from our perspective is relocation planning, right? So communication, very concise, clear, timely communication to residents is very much an integral part of developing a relocation strategy. So you're making sure that folks are being updated, and they're well informed. And it's also the initial step to, when things start moving forward, in doing the written documentation part, because there's a lot of requirements that need to be documented. And the notice does spend quite a bit of time talking about the plans.
And in terms of best practices, the notice only requires a relocation plan for permanent relocation. I would strongly encourage everyone to have a relocation plan, no matter what kind of relocation you have. It forces you to think through what you're going to do, identify the problems, and PHAs who have had relocation plans have had, just frankly, far fewer problems.
Great. So one of the things that comes up a fair amount is the Rad Right of Return. So Claude, can you talk through that? What does that mean?
The right to return is the right to return to the project in a unit in which you are not underhoused. So it's not a right to return to your specific unit, it's to the project. If the PHA does not have an appropriately sized unit, they can put you in a larger unit, but that tenant would then have to be moved back to an appropriately sized unit once one became available. And of course, the cost of moving from the original unit to the appropriately sized unit would have to be borne by the PHA.
And so some folks have struggled with really figuring out the right of return, and we've run across some situations where things that might have gone wrong. So what are some of the sort of hazard sites, hazard paths? What are some of the violations that might happen that people look out for?
You have to understand, there is no rescreening under RAD. People may not be able to return technically under your tax credit income requirements, but that doesn't matter under RAD. Everyone has a right to return. And if you are reconfiguring your project,
Right.
everyone still has a right to return. And if they can't return, then you have two choices. You either have to reconfigure your project so that everyone can return, or the requisite number of residents have to voluntarily relinquish their right to return to the project.
And I think what we've seen is in some older developments where the 4 or 5 bedroom configurations and they're being converted into 2 and 3 going forward, that there's families that have not been able to return. So that's something, you know, as part of your project plans, being sensitive to.
Yeah, you have a question.
Good morning, gentlemen. Good morning. Good morning, gentlemen. If you're doing temporary relocation on the same property that you're doing the conversion, would the temporary facilities have to be fully ADA compliant, or could you cut corners?
Well, from the URA perspective, they have to be comparable. So I think that's really what the program requirements.
And there are definitely fair housing concerns about making sure that there are reasonable accommodations. And you know, I don't know the precise answer as to whether it has to be a fully designated 504 unit, but certainly the residents need to be able to have full functioning of their of what they need in the unit during a temporary relocation. So it's the temporary relocation. There are a couple different types of temporary relocation. There's situations where folks are sort of doing a domino effect around a single site, and then there are situations where residents are being moved temporarily off-site and then back to the original site. And the requirements are a little different in each of those cases. Not speaking specifically to the accessibility question, in both of those cases, the particular needs of the households need to be front and center on your mind. But the requirements in terms of what triggers, what is triggered, for example, I think in the domino situation, the URA is a little different.
So under temporary relocation, where you're just moving from one building to another, the requirements are you have to pay whatever their moving costs are, reconnection of utilities and things like that. But typically, I think what we did see one instance where someone was moved and they were put into a unit on a higher floor than what they did, and there was not a good outcome. So I think it's really having common sense, being very sensitive to the needs of residents, and making sure that their needs are met during their temporary transition until they can return back.
Yeah. One of the guiding principles is to minimize tenant disruptions.
Correct.
So people need to be able to carry on their daily activities, whether they're temporarily relocated to another location or whether they're temporarily relocated on site. If they can't carry on their daily activities, then there's probably a problem.
You have another question?
Yes. My name is Aquarius Vaughn Gashri. I am an elect commissioner from the District of Columbia Housing Authority. As you know, we are one of many of the Move to Work housing authorities. However, we're not a state. We're a municipal corporation. I'm here to speak about RAD from a perspective of my constituents in which I represent as an elected official. One, with RAD, whether or not we will lose our public and Indian rights, which we have the right to resident participation funds. We also have a right to be an agent to our laundry room net income checks. We have the right to also fundraise. And I find that the trend when we convert from traditional, conventional public housing to any other form of standable, affordable housing, residents who have long fought to have 24 CFR, our rights are being taken away. And as I speak now, we have many rights that have already been taken away. So what would you do to assure us that, number one, if we decide that we will go along with RAD, you also have a group of people that will be moving in these complexes that usually in most cases are more organized than what we are, and they begins their own tenant organization, which leads us out because once you convert, you make a decision who moves in what unit first, whether it would be a traditional, conventional public housing resident, whether it would be, as you call, a housing choice voucher resident, whether it would be a mobile housing choice, because whether or not we want to accept it, those stigma also carries territorialism with us, because I'm territorial.
So there are several issues that you've raised in your question. The first was about rights under public housing rules in the 24 CFR, and which of those continue. And certainly when there is a RAD conversion, the property does shift from being a public housing property to a Section 8 property. So the Section 8 rules are the rules that apply. Now, we also recognize that there were concerns, precisely like the ones you just raised, about rights that have existed in the public housing context. And so a number of those rights were identified and incorporated into the RAD program and are carried over into RAD specifically RAD Section 8 contracts. So the right of the residents to form a resident organization, the requirement for funding for resident participation, the lease requirements, the lease termination requirements, the grievance procedures, those and a handful of others are rights that did not previously exist in Section 8, but were public housing rights, and because of RAD, they have been incorporated into RAD public housing requirements. So it is not exactly the public housing structure. It is still based on the Section 8 structure, but there is this overlay of additional RAD protections and rights of the residents that were pulled over from public housing into the Section 8 program specifically in RAD contracts. You mentioned several other elements, some of which are questions of local decision making. So for example, the RAD program does not get into what happens with the proceeds of laundry room revenue and that kind of thing. Those are local decisions that are made between the various folks involved at the local level. So that's the kind of thing that in the resident consultation, in the meetings, as you are planning the RAD transaction, those are the kinds of questions to be asking the housing authority so that you can all get on a common understanding of whether those arrangements will roll over into the post-conversion contractual arrangements or whether there's a change for some reason. And then finally you mentioned, or one other thing that you mentioned, that you talked about the kinds of folks that might move back into the RAD property afterwards, whether they're HCV, housing choice voucher holders, or public housing tenants. And I think there's a distinction that I want to make clear, that when a property is converted under RAD, it is not converted into the many different other kinds of affordable housing that exist. It's converted into a RAD property, which comes with all of its own structure. The current public housing residents certainly move, maintain their tenure under the right of return. And there are requirements for how the waiting list gets migrated over. The public housing waiting list then gets migrated over to being a waiting list for that RAD property. And the local conversation between the residents and the housing authority may result in some changes to how the waiting list is administered or something like that, but that's all done through the normal processes for changing the administrative plan and that kind of thing that does have its own resident involvement procedures. But the RAD property is not a property where other mobile voucher holders can move in because it is a project-based subsidy at that site. So it is there is structure around who can move into a RAD property. So you had another question.
Hi, I'm back. Charlene Nimmons.
Yes, and some of your questions earlier you might want to reiterate because this conversation might be the place to have the answer.
I got it. I'm from New York City, so we're the largest public housing authority in the country. We're not the oldest. We thought we were. We had a discussion in the back.
Little rivalry, huh?
But we're the largest. And I'm hearing you say that you're about, or what you want this process to be about is the protections of residents. How are we picking and choosing which of these HUD regulations should be selected? When I read the HUD regulations, I find a lot more that should be included. And I look at 24 CFR Part 970, which comes up out of Section 18. That's how I found it. And that has a lot of protections within it that talks about environmental concerns, relocation. Actually, it even speaks to how an offer should be made to the resident association if they choose to purchase that property. All of that is in there. So I would like for you to look at that HUD regulation. Then I look at 964.18, 964.135, and I start thinking about that residents are supposed to be a part of the decision-making process. But yet, we're being told what is going to happen rather than us being at the table from the onset, because that's HUD rule. That's not something that I created. That actually came from the government. When you talk about rent differences, public housing, you have an adjustment scale that goes, it can fluctuate up and down when it comes to your rent. So if my if my income decreases, my rent decreases. It's low income housing, it's not affordable housing. And so if I have low income housing and now I'm being shifted into a program that is affordable housing, but it doesn't give me that same protection where my rent can fluctuate, I could be in dire state. Is there a rule that you have in place where the residents can opt out of RAD? Because we are and signed on to public housing. So we should have the right to opt out of RAD, especially when you first sign up, which I did 30 plus some years ago. I had the option of whether I wanted to be a part of Section 8 or public housing. Once I made the decision for public housing, I no longer had the right to convert and go into Section 8. I want to maintain that right. I want to continue to have public housing. I say I, but I'm talking about for those who I advocate for. Because actually, this is not impacting me in that way. And we'll talk to you later about some of the other things we want to talk about. But I'm not being impacted in that way, but I'm standing before you saying that there are many people who are being impacted across this country that need you to protect the way that you have outlined in your HUD regulations.
So thank you. So there are a couple things that I wanted to talk to you about that. The first, and I'm not necessarily going to go in the same order, but I'm going to try to remember to hit all of them. The first is, I think, perhaps a misunderstanding about the rent arrangements, because both Section 8 and public housing, the rent is calculated off of the tenant's income. So after a RAD conversion, this is still, as you describe it, low-income targeted housing, as opposed to the affordable housing, where the rent is a set number regardless of what your regardless of what your income is. So in the Section 8 context, in a RAD context, there is the mechanism for your rent to fluctuate as your income changes. You also mentioned the question of whether a household could opt out of RAD. Certainly, it wouldn't be logistically possible for a unit at a property to opt out of RAD, but there is a mechanism in the rule for any household that doesn't want to leave the public housing program. If the housing authority has other public housing, they can get a priority to move into another public housing unit that is not going through RAD. So it's not an unlimited thing, but particularly if the housing authority is converting a lot of their portfolio, then there isn't public housing that may still be available. But certainly in a larger city where there are other public housing properties that are not going through RAD, there is a mechanism for residents who want to stay in public housing to request that transfer to a property that is not going through RAD. And you mentioned a number of provisions relating to relocation protections and environmental reviews and that kind of thing in the Section 18 context. And actually, the relocation protections in RAD are very strong. The environmental review is strong in the RAD context as well. So while the rules may be a little different, RAD applies the uniform relocation rules, whereas public housing has there are slightly different relocation rules in the public housing context. But I think that in the vast majority of the situations, the RAD rules, the URA rules combined with the RAD rules are in fact probably more protective of the residents in terms of the relocation rights. So I think that there are a lot of the things that applied to public housing that the concepts, at least, and in many cases the details, have been brought over into the RAD context. There was a lot of thought when RAD was first set up several years ago about which should be brought over into RAD and which should not. And there were some things like the question of the resident, the offer to purchase to the resident, that there was a decision that not be brought over. And some of that was in order to try to make the possibility of financing the transactions easier with the goal of being able to deal with the capital backlog. There were certainly debates about all of these provisions. And so judgments were, the folks designing the RAD program at the time made judgments about which to include and which not to include. That doesn't mean we can't revisit it, but those were the decisions that were made at the time. And for the most part, we have not been inclined to change those decisions. But certainly if you have specific things that you think we should look at again, happy to have those conversations.
Okay, I'm Rachel Johnson. I'm from Florida, and I just want to, I wear many hats in this housing. I started out as a property manager, and I went to a Section 8 voucher tenant and project-based Section 8 tenant from the point of view of my child being ill and medically ill and things of that sort. And then it led me into the advocating for the rights of tenants because I ended up losing my housing and things of that sort. So I just want to shed light to all of the housing authorities that people like us are friends. We're your friends. We're the people who can help you improve the property to make things work. In case in point, in Miami, there's property there that us as advocates, we don't want to be seen as troublemakers, which is what they call us. So, troublemakers in the sense, we laugh and things of that sort, but we want to be seen as the people that's going to come to help you with your investment, because at the same time, it's an investment for the people. And so the thing of it is that when you have this RAD, I remember this room some years ago, we were here talking about Petra, which ended up being RAD. And Sean Donovan, former Secretary Sean Donovan, promised to bring the residents back. So we weren't allowed to speak on particular things or circumstances that happen when you guys make decisions about people's lives. And so one of the questions that I have is that there was a promise made to bring people back, to bring those residents, to bring those advocates back, to speak on what they want to speak on, because you guys asked us to come to speak on what you wanted to speak on. And so the thing of it is that RAD has been imposed in people's lives, and some things you don't see. Some things you guys don't see what happens. See, whereas I am a very hard worker. I worked all my life. And to be placed in a position of losing your household based on a decision to not include medical, to not include this, or to downsize a unit, or whatever these circumstances are, it affects people so much. And so to include the tenant from the beginning to the end is very important. Public housing is very important for people to become self-sufficient. You'll have more people getting out of housing rather than staying there generation and generation and generation. The Section 3 has helped me to create my own nonprofit and to be employed and to do more things to help other people that was like I was. So you have got to include the people from the beginning, the residents, because you're not walking in their shoes. There's little things that takes the turn, and just like the man said, just include them. Include the people in it. I mean, just the downsizing. I mean, there's people being forced to, and I've seen this myself recently, signing documents to downsize before the RAD process starts. So although you don't have that chap yet, they're already started a process of forced evictions way before. There's different tactics and strategies and things that are happening way before it gets to the chap or before it gets to the RAD. And I understand that this is a business, but it has to be people over the profit, because you win.
Thank you. Yeah, I think one of the things that we are really trying to emphasize here is having that conversation with residents from the very beginning stages of the thinking about the RAD conversion, so that the residents are part of the conversation all the way through. I think that certainly once the RAD rules apply, which is when, and they start applying very early in the process, the RAD rules are relevant as soon as you are applying for RAD and as soon as the CHAP kicks in. The issues of preserving the right to return making sure that residents have a unit that is comparable to their current unit as long as they're not overhoused. Sorry,
Not under-
the not. So the resident has to get a unit that is at least the size of their current unit. They can be overhoused if that's the only available option, but the right of return is to the size of the unit that they should be in. That doesn't mean that after the conversion, under public housing or Section 8, there are rules about right-sizing households that are in the wrong size unit, and RAD does not overrule all of that, but it does ensure that residents have the right to return to the unit at their property when the conversion is complete. So, and then you also mentioned Section 3, which thank you for drawing attention to that. Section 3 is a priority of the Secretary. It is also something that has been incorporated into RAD, and so it is something that that everybody who's contemplating a RAD conversion should be planning for as you think through your construction work. So I think this may be the last question, but
Thank you. I'm Beverly Wilborn. I'm the Executive Director for the Housing Authority for the City of Annapolis. I echo the residents' concern. Let me say from the Executive Director's desk, what I hear all the time as we're going through RAD is just what you've just heard. It isn't just that, yes, we're going to return those residents and we're going to lose no units, and for that we were very appreciative. But the fact is, in exchange for the funding, as Baltimore said, do I want to do it in 200 years? Do I want to do it in 2 years? In exchange for the funding, the management fundamentally changes. You see, in the public housing arena, residents sit on our boards. As I always say, you are not going to sit on the boards for developers. You don't know where they are, but you know where I am. That's the governance, that's the touch that we are losing, and I believe we should look at closely. And the reason that it's being lost is the financing tools, which have traditionally been for developers, suddenly apply to public housing, and we show up and they say, well, you don't have the experience in developers. Well, no, of course not. I've just been public housing. And so there's not that bridge, and that bridge should take place because that's the fear that you're hearing, that the people who they know where they are, they come to me every day. They tell me what's going on, and they know they can get to me. That's what's losing in RAD as much as we need the financing.
And I think those are, it's an important set of questions on how the Housing Authority decides to implement the RAD transactions. So the Housing Authority can choose to be can choose to bring in a developer partner, or can choose to be its own developer. That choice, as we've just heard, is an important choice that impacts the residents, which is why that is one of the things that we now require be talked about in the resident meetings. And if the pre-application resident meetings, you haven't made that decision, then you say that, but then you need to have that additional meeting when you start getting to the point of making that kind of decision. So the question of can the Housing Authority be the developer itself and have the, in a tax credit transaction, have the Housing Authority be the general partner, and the Housing Authority Board, which includes the resident members and includes leadership that is accessible, like in Annapolis and like in many communities, that is a choice. But as the questioner points out, not every housing authority has the track record that investors are looking for, and they may need to partner. Do they partner with another housing authority, and maybe that provides more of the kind of accountability that the local government is, that the local community is looking for? Do they partner with somebody else, a for-profit or a nonprofit, but maintain a minority share and try to maintain the kind of relationship that was just described through that vehicle? Do they set up some sort of advisory board that I know that some cities have established an advisory board to work closely with the developer partners when they have chosen developer partners to be involved. And they've put that into their master development agreements and their contractual documents to respond to what the local community decision making has been about that ongoing involvement. There are a lot of different ways that the local housing authority can structure this relationship, and we encourage the housing authorities to have the conversations with the residents, with the community, to figure out what is right in that community. And ultimately, it's the housing authority's choice as to how to structure the deal. HUD is not dictating any of these structures. We are requiring the conversation happen. We are requiring that in the meetings with the residents, the housing authority talk about whether they are planning developer partner involvement, whether they are planning some of these other major pieces of a transaction, so that that conversation can happen, and so that residents are aware of and informed of what might be under consideration, so that the residents can be part of the conversation. So we have tried to make the rules such that the residents can be part of the conversation, and we have tried to make the rules such that it is the local housing authority that is driving the answer in consultation with their residents, including their resident advisory boards, including their resident board members, including whatever additional context that local community wants to have in terms of making those decisions. So we feel that it's very important for the residents to be part of the process, and we are looking to the housing authorities that are applying for RAD and participating in RAD to take the spirit of that. And I know many, many housing authorities across the country do take the spirit of that. And you've heard some of the good examples, the collaboration that the City of Austin Housing Authority did, the kind of conversation that many housing authorities have around these issues with their residents. And what we would strongly encourage is all of the housing authorities that are thinking about whether RAD works in their context, think about these issues, think about how others have involved the residents, think about the variety of joint venture arrangements that can be implemented to fit the balancing of the financing needs and the local participation needs that folks in your specific community are looking for. So there are clearly, as you can see, lots of important issues in the arena of resident rights. There are also a lot of issues in the connection with relocation and resident consultation. I know that folks will be around at the tables later in the day for more detailed conversation. And of course, this is a good topic to keep talking about with all of your HUD contacts, with your transaction manager. And we will try to be as helpful as we can guiding you through the RAD rules as you're planning your transaction. So I think what's next? Ben is next to tell us what's next.